Hello, doctors. I'm Dr. Chris Rapoff of EASY QME Continuing Education, and welcome to this week's Case Law Update. Several weeks ago, the Workers' Compensation Appeals Board issued an en banc decision in the Nunes versus the State of California Department of Motor Vehicles, which we discussed at length in a previous update for you. But this case did resolve an issue related to vocational apportionment as it pertains to workers' compensation cases. Today, we're going to explore the case that more or less triggered the Nunes versus DMV case, the Soormi versus Foster Farms workers' compensation ruling. But first, let's briefly review the Nunes case en banc ruling. So it was well established that an employee's disability could be apportioned pursuant to Labor Code Section 4663, even if it was determined that he or she had 100% loss of future earning capacity. This was dealt with in the Acme Steel versus the Appeals Board in a 2013 decision. But there was a dispute as to what role, if any, a vocational expert had in the apportionment analysis. Now, in some cases, the Appeals Board adopted opinions from vocational experts that applied something known as vocational apportionment. Some vocational experts asserted that the vocational apportionment is not the same as medical apportionment. So it wasn't uncommon for such experts to find that a vocational apportionment didn't apply and that an employee was 100% disabled when an employee didn't have work disability prior to an industrial injury, again, a pre-existing condition. However, in other cases, the Appeals Board rejected the concept of vocational apportionment and held that the apportionment had to be consistent with Labor Code Section 4663. In June of 2023, roughly 6 weeks ago, the Workers' Compensation Appeals Board issued an en banc decision to resolve the issue affirmatively. In the Nunes versus the State of California Department of Motor Vehicles, the Appeals Board held 3 responses. Number 1, they said that Labor Code Section 4663 requires a reporting physician to make an apportionment determination and prescribes the standard for the apportionment. The code does not make any statutory provision for vocational apportionment. Number 2, vocational evidence may be used to address issues that are relevant to the determination of permanent disability. And number 3, vocational evidence must address apportionment and may not substitute impermissible vocational apportionment in place of the otherwise valid medical apportionment. Getting to today's topic, prior to this en banc decision, there was another important panel decision, the Soormi versus Foster Farms, which rejected the concept of vocational apportionment and found that the injured worker to be totally and permanently disabled. This is the 2023 Soormi versus Foster Farms Workers' Compensation Appeals Board case that we will discuss. The facts of this case are that Mr. Soormi emigrated to the United States from Iran in 2008 and worked as an unskilled laborer for Foster Farms for 11 years prior to his injury. Mr. Soormi did not speak English and completed the 9th grade while in Iran. In August of 2019, while he was attempting to repair a machine on the production line, Mr. Soormi's right hand was crushed and burned. He sustained multiple fractures of the fingers and was later diagnosed with chronic regional pain syndrome, or CRPS. AME evaluated Mr. Soormi and found that he had suffered a 24% whole person impairment to the right hand, with restrictions precluding Mr. Soormi from activities that required gripping, manipulating, or dexterous tasks using the right hand. Mr. Vega, an applicant's vocational expert, conducted a vocational testing and performed a transferable skills analysis. Mr. Vega reported that prior to the injury, Mr. Soormi had access to a wide group of occupations in the medium, light, or sedentary exertion classifications. However, the transferable skills analysis did not produce any reasonable occupation options for him due to his limitations of gripping, manipulation, and dexterous tasks. Makes sense. Now, the defendant's vocational expert, Mr. Simon, found that Mr. Soormi was amenable to vocational rehabilitation and suggested hand grinding and polishing as an occupation for Mr. Soormi moving forward. So after the case was presented, the workers' compensation judge provided an analysis. This analysis read that the report and recommendation explains that the permanent disability is irreversible residual of an injury that causes impairment of earning capacity, impairment of the normal use of a body part or system, or a competitive handicap in the open labor market. They also explain that while the permanent disability rating schedule, they're presumptively correct, this presumption is rebuttable. So in the ruling, an essential elements checklist for determining permanent disability is discussed, and you can read that in the case itself. And it also included an analysis in the industrial injury and also work preclusions caused by the injury and whether those preclusions prevented the injured worker from gainful employment in the open labor market. So the workers' compensation judge based their findings of permanent total disability on the vocational reporting of Mr. Vega, the applicant's vocational expert. If you recall, he found that the applicant had minimal skills and was unable to find any reasonable occupation. Now, the opinions of the defendant's vocational expert, Mr. Simon, actually were found to lack substantial evidence due to his lack of discussion of the effects of the injury on vocational retraining. So Foster Farms, the defendant, contended that apportionment on a vocational basis is required, but the judge rejected that claim as the injury was found to be 100% industrial. So finally, in their report and recommendation, the workers' compensation judge explains that the employer is the one who gains benefit of paying an unskilled laborer at or near minimum wage, and thus they must bear the burden of the permanent total disability award. If you recall, Mr. Soormi was an immigrant from Iran, had a ninth grade education, and did not speak English. So therefore, that was part of the basis for their opinion as well. So what do the Soormi and the Nunez cases really stand for? Well, simply put, they determine and finalize that apportionment must be based on the existence of a pre-existing disability. Only where substantial medical evidence, either medical or vocational, demonstrates the existence of a pre-existing disability will apportionment even be allowed. A worker's limited education and inability to speak English, in the case of Mr. Soormi, that were not labor disabling prior to the injury are not appropriate factors of apportionment. So in conclusion, we have a very intriguing and an interesting set of circumstances here. We have the Soormi versus Foster Farms case, a prior ruling that set the stage for the appeals board to make a very determinative, landmark, final en banc decision on the concept of vocational apportionment. And the appeals board set the record straight on this subject as well. This is a teaching moment and a very well learning moment for the QMEs as we deal with the sometimes daunting task of providing an accurate opinion when it comes to apportionment. So once again, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you again for taking the time to join me in this presentation. I hope you enjoyed it, and I do look forward to sharing some other interesting cases again with you real soon. Thank you.